There you go. We can see it now.
Okay.
Good morning, everybody. We're just giving it a couple minutes to let everybody get connected. I'll give it probably till like 11:02 or 11:03. We have a lot of people here today. Okay. Well, everybody's connecting. I am Julie. I am the office manager and director of marketing here with Aged. Sharon Rich, our senior trust advisor, who typically runs our webinars, could not be with us today, so I'm hosting in her stead. So welcome everybody to our webinar. I wanted to do a little bit of housekeeping. For this presentation, we are offering educational credits. So we have CEs for guardians, attorneys, CSAs, and we do offer a general attendance certificate. So if you have another kind of certification, you could probably use the general attendance certificate to get those credits. This webinar is also going to be recorded, so you are able to access the recording afterwards. We also have all of our webinars on recording. It's available at www.trustaged.org/training. And on our training page, you can also view our past webinars, and some of them still have CEs and CLEs you can obtain. There's a little survey you have to fill out, but otherwise it's pretty easy to get those credits. So if you guys are needing additional credits, we always have the previous presentations on our page, and then we put the current presentations on our page. So if you have to leave part of this presentation, we will definitely record it and have it up on our website. As far as the CEs go, if you give us about 5 business days, we'll get everybody all their certificates and a copy of the slides from today. So just know you will get a copy of today's slides. But we do need a couple days to kind of wrangle all the certificates and all the credits and all that stuff for you. Today, as far as the presentation goes, we're asking everybody to put your questions in the chat. We're going to monitor those questions throughout the presentation, and we will answer them as we see fit. So Carol and Carl are actually going to monitor all that during the presentation. And it's 11:03, so I wanted to introduce our guest speakers today. Carol Felsing is a CPA. She joined Berman Hopkins in 2023 as a tax partner overseeing the estate and trust department following the strategic merger of her firm, Felsing LLC. With a distinguished career spanning over 30 years as a licensed certified public accountant, Carol is a trusted professional in the financial realm and assists clients with trust and estate planning, compliance services, litigation support, representation before the IRS, and tax planning. She has extensive experience working with estates and trusts, including serving as trustee and executor. And joining her is Carl Erickson. He joined Berman Hopkins in 2023 as a tax manager within the estate and trust department, following a strategic merger with Felsing LLC. With an outstanding career spanning over 25 years, Carl is a respected and trusted professional within the financial realm. He assists clients with trust and estate planning, compliance services, litigation support, representation before the IRS, and tax planning. And with that, I'm going to turn it over to Carol and Carl. Thank you very much for joining us today, Carol and Carl.
Thanks, Julie, for inviting us. And I'm looking at some of the attendees there, and I'm seeing several guardians that I've worked with. And before I start this, as I told Julie, there's a special halo in heaven for the guardians out there. Your job is a very difficult one and sometimes very underappreciated. So I want to say thank you for what you do, because it's definitely not an easy one to go through. When we're looking at that, Kate, do we know how many we've got, of which, if we've got more guardians, attorneys, CPAs, trustees? What do we have?
I'm not sure I can review the answers until everyone comes in. Do you want me to look at them now?
Or just take a gander. I'm just I want to focus, because my guardians will want something a little bit different, but we can, just let me know once you get them in, and we'll keep going with what we've got and start from there.
Okay.
What I thought I would do, and I take it more from the perspective as trustee. Now, I will serve as guardian of the property, but not the person. But I also serve as trustee and executor. I've also been involved in a lot of litigation, trust litigation cases, and we'll kind of talk about that at the end because Carl's helped me. We've had some experiences and some things I think I should write a book over of what's happened in some of this area. So what I thought I would do is to take it from the approach of, okay, you've been named trustee. Now what do we do? Where do I start? Because so many people that serve as trustee have never done it before. Or they're doing it in a very, very limited fashion. I mean, I've had several cases that I get involved in that you've had a financial professional or an attorney service trustee, and it's the only one they've ever done. And that sometimes gets you into a lot of trouble. So the first thing when you get named as trustee, get a copy of the trust document. And that includes when CPAs are preparing a trust tax return, get a copy of the trust document, because without that, you don't know what the tenets of the agreement is. You don't know what you're supposed to be distributing. You don't know what the parameters by which you make distributions under, what are the limitations. There's a lot of information in that trust document. And if you're not familiar with reading the trust documents, which you're going to need to read through. I have all my staff, when we get a new trust in, we highlight the pertinent portions, and we literally do a brief on the trust document so we can see what section to go to when we have a question. So we don't have to read that whole 100-page document again. But oftentimes, and I was very, very fortunate when I started this probably 20 years ago, I had a couple attorneys, there was a need for what I was doing. And there was a couple of attorneys in particular that came beside me and literally helped me get to bring me the knowledge that I needed to have. So a lot of attorneys are out there, are willing, they need help in this area, and they are more than willing to help those trustees or even the CPAs or whatever and guardians to learn that document and understand what the tenants do. So, you know, I've had a couple that maybe not so much so, but for the most case, I will tell you, most attorneys that I have worked with have been very, very willing to help bring you up to speed if there's some questions you have or questions on, you know, does this qualify for distribution, especially when it comes to, for those of you dealing with special needs trusts, which we'll kind of touch on briefly. But those are very specialized, and the distributions you can and can't do, very, very specific things that you have to abide by. The next thing you're going to need to do is who are your beneficiaries? Who are your current beneficiaries and who are the remainder beneficiaries? What the contact information? What's your social security number? Because you'll need all that information at some point in time when you go to do the trust tax return or when you go to do accountings for them. And if it's a new trust being created by someone that has passed, you're going to need to get someone to get the EIN numbers. So often I see that we've got a new trustee coming in or even a guardian, and they just keep the existing account open under their person's either individual name or under their revocable trust name that still has their social security number. And that causes issues down the road, because now we've got income being reported under a social security number that the person is no longer alive. So that causes quite a few hiccups, if you will, going down the road.
So Carol, let me pause you for a minute just to circle back to your question. Primarily our audience today is guardians.
Okay.
So primarily the bulk is guardians today.
Okay. So when we go with, when we'll talk a little bit, I'll focus mainly on guardians, because some of this is things that they need to know, because they need to know who to surround themselves with when we're talking about that. But they need to know, go and ask, okay, for a purpose of employer identification, usually they need to go ask that CPA or the attorney, listen, this is what I've got, this is what I need the EIN number for. If we have a revocable trust, because oftentimes they get involved, the guardian gets involved if the person has a revocable trust and they're no longer competent, they can no longer serve as trustees. So a successor trustee comes in. That may or may not be the guardian. It just depends on the, you know, what the arrangements have been made. But if you have a revocable trust that the grantor, the person that started that trust, is no longer competent to serve as trustee, you do need to get an employer identification number for that trust now. So let's talk about some different types of trust. I just wanted to throw some out there. Revocable trust, that's typically what you're going to see when the person's alive. That means it's a grantor trust. That means that they can change it at any given time. We've got intentionally defective grantor trust. We get revocable trust. There's a whole host here of types of trust. And so you don't know what you're dealing with until you get the trust document, right? So I just throw that out there because not all trusts are created equally. And you need to know what you're looking at. I've seen a lot of errors in the realm of intentionally defective grantor trust. That's a little bit of a misnomer that it is a revocable trust for income tax purposes, but it's an irrevocable trust for gift tax and estate tax purposes. So you just need to know what you're looking at on some of those. So we've read through the document, we figured out which kind of trust document it is. And if it's a new trust, it's a little bit easier in that, you know, you're getting to set the groundwork, you're getting to go in and establish what the parameters are going to be and how the distributions are made. But often cases, I'm brought in and the guardians may or may not be brought in midway. Say they had a previous guardian or say they had previous trustee. A couple things you need to do, and even as guardian, because guardian's not going to be responsible for getting their tax returns done, right? Guardian's going to be responsible for doing any of the things that the individual would have been responsible for themselves. So I always suggest you go back and get 3 years of the last tax return years, both for them individually and for their trust, if they've done separate trust tax returns. Get previous accountings, whether that be trust accountings or any guardian type accountings, because all of you have to submit your accountings to the courts, right? Make sure you get a copy of that, and you would be surprised at the amount of people, especially family members, particularly, the records are less than stellar, shall we say. And as part of that, when I take over as trustee or guardian of the property, I always make sure I get a waiver signed that I'm not responsible for previous actions or determining previous actions. I can't tell you how many litigation cases have come up because the guardian or trustee got involved and they think, you know, the family members or whatever think that they should be responsible for finding errors of the previous guardian or trustee. And that's not your job unless you're specifically told to do that by the courts. So I always, always, always make sure I get this signed waiver of liability to limit my liability. I want to be responsible for what I do, but I don't want to be responsible for what anyone else does. And I don't want to be responsible for finding it. Now, that doesn't mean I'm not going to find it, but I don't want to have the responsibility of making sure I know that they took money 5 years ago, you know, and I should have figured that out. You're also going to need copies of bank and investment statements for them because you're going to have to change titles, right? You're going to have to change how that titling goes or where the address goes, because you don't want that statement being mailed to that individual anymore if you're able to keep them still in their home. Because chances are, if you have it still mailed to their home, you're never going to see it. And they also always either end up in a big stack, and the stacks, especially if you're dealing with people that are not competent to handle their affairs, that paperwork could end up anywhere. So we need to make sure we get copies of all the previous bank statements and investment statements. And a great place to start finding that is looking at their last year's tax return. Because if you have that tax return, you can go to Schedule B and you will see where they earn their interest and dividends from. Great place to start. You will also see if they have any investments via partnership or something like that, because that will also be reported on that tax return. So that's where you go to get the information. Say, hey, I know I'm looking for this K1 from this partnership, so I need to contact them and make sure they understand either it's going to be a new trustee or I need to change the address or both. So that's typically where we start when we take over for a previous trustee or executor or guardian.
Carol, before you flip the slides, we actually had a request. Can you go back one to the previous slide about all the types of trusts for just a moment? I think they just wanted to peek at this a little bit longer for a minute.
No problem.
And then we did have a question while we're waiting. Who do you have sign the waiver when you get that waiver done?
And it depends on where it's coming from. If I'm being ordered by the court, and there was a previous grantor or a grantee, or there's a representative, I will have the beneficiaries or the representative of the beneficiaries or the judge sign that agreement.
Great.
Someone that's representing on behalf of that individual. Or I also sometimes have, if I have a previous trustee, you make them sign a statement that they're responsible for anything else, but you really need the beneficiaries, the family members, to sign, because that's where you're going to get sued.
Perfect.
Right?
Thank you. And as a reminder, we will be sending these slides out. So if you guys are trying to scribble lists like this down, we'll be sending them out to everybody. So you guys will get this information.
Yeah.
Okay. Thank you for pausing on this, Carol. We appreciate it.
Yeah. And I think sometimes too, I get guardians involved, or even family member trustees. They don't even, if they've never really done a lot of this work before, they can't look at the trust document and figure out what they've got. So I think that's where you really don't be afraid. I know some of the guardians, some of them are dealing with individuals perhaps that don't have a lot of funds, if you will. But there are places. I know Agent is a real support network for a lot of guardians, and they have a support network of attorneys that are very, very familiar with revocable trust, irrevocable trust, IDGTs, special needs trust. If you don't know who to ask, call Julie or call Sharon, and they can put you in touch with someone that does. And I will tell you, a lot of people say they do estate and trust work from any professional side, whether that be a CPA, whether that be an attorney, whether it be an investment advisor. Pick someone that does it almost exclusively, because this is not an area that you should dabble in. We find that a lot, especially in the investment world, because how you invest for a trust or a guardian is very, very different than how you would invest for an individual. And it's not the same. So, okay, so now, okay, we've got our trust document. We've figured out that I've got a revocable trust that now is still as long as the person is alive, that trust remains revocable. Because you can go to court and have a tenant of that revocable trust changed. Only upon their passing does it become irrevocable. So we've got this, we've got the assets. We know, okay, we're going to change the trustee on it, or we're going to change, the guardian's going to now be responsible for this. These are some of the items that you have to go through and change the titling on. If there's annuities out there, you need to make sure that they know where it's going now, that you're either the new trustee or you're the guardian, because if not, they're not going to know that. Bank accounts, very, very important that you get all that stuff changed over. And in fact, a lot of times I will change the account entirely. I will have, because I don't want to be responsible for payments coming out, especially when you have family members that have got caught with their hand in the cookie jar. They probably have login access to that account. So I typically will change the account numbers. And oftentimes, unless there's a lot tied to it, I would suggest all of you get with a bank that you know well, that you have a personal relationship with, and put your accounts there, all of them. Sometimes you want to stay nice with existing people, the existing financial people, if they have it. But for a bank, I mean, I have a bank that I particularly use, and I know what they want. I know what I need to give them. I can send it to them via email. I don't have to go down and make appointments and sit for 3 hours while they figure out what they need, And there are some banks that are much, much more difficult to deal with than others. And if you have one contact person that handles all of these for you, you will have it down pat. You'll have a checklist. You'll know exactly what to send them, you know what their forms look like. They've already been through it. They know what you need. And so we're not having to recreate that wheel every single time you try and retitle. The investment accounts as well will need to be retitled. They require different things. Most of them will require a medallion guarantee. So you need to be prepared for that. Real estate is another big one that you need to look at changing the trustee on. Just because you want to get notices if the real estate taxes haven't been paid. You want to get notices if someone puts a lien on that account on their residence, which I've dealt with because something didn't get paid. And you see that more in a homeowners association or a condo association type deal. You had no idea that the previous trustee or guardian wasn't paying certain bills. You have no idea knowing that unless you're going to go back and be paid to, do some kind of forensic accounting on it. So all of a sudden a lien gets slapped on you and you have no idea why. So you need to make sure that contact information has been changed for you. Any questions on that one, Carl, coming through today?
No, we just had the previous question about the signing the waivers, the only thing so far.
Okay.
But as a reminder, as you guys have questions, please put them in the chat.
Okay. We talk a different language, kind of like medical people talk a different language. We talk in acronyms a lot. You'll see all these acronyms, IDGTs, SSDI, simple trust, revocable trust. And oftentimes, who's a trust protector? What's a SNP? What's a CRUT? What's a CRAT? So I'm going to go over some basic definitions so you have them, and they're going to be in your slide presentation. What's a Q-tip? What's DNI? And we're going to go over DNI because I know that's a lot of questions. A lot of guardians and new trustees know, how much do I distribute? How do I determine that? And we've got some cases that we're going to show up on that. So some of these you'll see, like durable power of attorney versus regular power of attorney. We'll talk about that one. What's irrevocable? What's revocable? What's HIMS? I talk to new trustees, and I'll ask some professionals, and you'd be surprised. And I'm not pointing the finger at any one professional. I'll say it's across the board. I'll ask them, well, is it a simple trust or is it a complex trust? And my answer, probably 75% of the time, well, it's pretty easy to work on. And that has no bearing on whether it's simple or complex. So we'll kind of show that. So let's talk about some of these. Grantor, we probably all should know the grantor is the person that establishes this trust. And then once a trust is created, there's two types of beneficiaries. There's an income beneficiary and there's a remainder beneficiary. During the life of that trust, as long as it's revocable, meaning that the grantor can change it at any time, he's the only one that needs to have information on that trust. The statutes require that you give accounting, but if you're your own trustee, you're going to waive that accounting. You're not going to have anything formal in writing, but you're going to wait. You're not going to prepare accounting for yourself. However, once that trust becomes irrevocable, meaning the trust cannot change, typically either the person has died or we've created an irrevocable trust to use up part of their gifting amounts. The remainder beneficiaries, meaning if a parent dies and their child is the beneficiary, but if something happens to that child, the grandchildren are now beneficiaries. They're called remainder beneficiaries because they have a potential interest in that trust. And this is a big mistake, and this is where we see some significant litigation, is that the remainder beneficiaries weren't put on notice with what was being done. And so if a trustee was playing to the whims of the child in this case and not abiding by the trust document, meaning that assets were being spent that should not have been spent, that's where your litigation, that's where your liability is going to come from, is from those remainder beneficiaries, because they do have a right to that information, and they do have a right to question expenses and income being made. Okay, so that's a big key. Who are your beneficiaries? Not only income, but remainder beneficiaries. And that is a mistake I see a lot of times. And even we serve as back office for quite a few trustees doing accountings. And I'm very specific on my accountings. You need to give this to this person who is your current income beneficiary, as well as these remainder beneficiaries. And a lot of times they choose not to do that, but they're choosing not to do it as trustee for them, but I need to put them on notice that that's what they need to do. And whether they choose to do it or not, that's their liability, not mine anymore. Trustee, pretty self-explanatory. Who's the person responsible for managing the trust assets and administering the trust according to plan? Simple trust, which I kind of expanded on before. Simple trust is a type of irrevocable trust that requires all income to be distributed to the beneficiaries, all distributable net income, with only principal being allowed to be distributed for health, education, maintenance, and support. And they cannot make any charitable contributions. The other, and we'll go to the next one, complex trust. Complex trusts do not have to be difficult to work on. They can have just one 1099, but what a complex trust means is that trustee has complete discretion over what distributions are to be made out of that trust. And they can make charitable contributions. Now, a big misnomer is simple trust. If a simple trust has passed out all the income of the trust, but by tenets of the agreement can make a distribution of corpus for purposes of health, education, maintenance, and support, and does make a distribution of principal, it is now taxed as a complex trust and not a simple trust. I see that mistake a lot of times because so many in my world, the CPAs, when they think they have a simple trust, they say, well, all income's got to be distributed out. And they don't bother to get the distributions. Well, but they don't know whether the distributions were actually made or not. And they don't know if they made distributions in excess of D&I. So if the trustee does not make the distributions of D&I within and it's just a reasonable period of time, it's not by 315 or 36 like a complex trust, that can be deemed, the IRS will deem that a gift to the remainder beneficiaries because they haven't taken something out of the trust and put it into their own estate. So it is deemed a gift. And I've had cases that when I've looked at people preparing the tax returns have gone for over a decade not looking at that. So, and the IRS did come down on them. Special needs trust, we're not going to go into a lot of detail on special needs trust because that in and of itself is a class all by itself. And Julie, I'm sure you've done a lot on the special needs trust educating, but you do have first party and third party. First party is a grantor trust because it can be revocable. They have access to the assets to do whatever they want. And they get some. Third party is typically a parent making a SNIT, we call them special needs trust SNIT, on behalf of typically their child that's disabled. But again, very, very specific guidelines by which a SNIT must operate within. So if you need to have yourself surrounded by professionals that is very familiar with them and do a lot of these because it's not anything like a regular trust. Durable power of attorney. This was something that came aboard I'm going to say over a decade ago. It could have been longer than that. Time kind of flies on me. We used to have powers of attorneys, and you still see some powers of attorney out there. But in most, all of your estate planning documents now have durable powers of attorney because they last beyond the person becoming incompetent. A power of attorney typically regular power of attorney only remains in effect while the person is competent. But once a person becomes incompetent, not so. So that's why everyone pretty much has gone to these durable power of attorneys, unless it is for a specific action. Sell real estate, particularly, say I've got a client that's going to go out of town. They can't deal with the real estate. They'll give a professional power of attorney for that act alone, right? But these durable powers are what you need. A mistake I see with durable powers of attorneys, while yes, it does grant the person power to act on behalf of the grantor, it does not grant them the ability to serve as trustee if the grantor was. So if I had John Smith that was grantor of his own revocable trust, and he gave Sally Sue a durable power of attorney, if John Smith becomes incompetent for whatever reason, Sally Sue cannot use her durable power of attorney to step in as trustee. Does not work for that. Another mistake we see readily being done. So that's a little bit of an issue that I see coming up. Distributable net income. I don't know. This is where I think a lot of people get a little confused. You've got taxable income, you've got accounting income, and you've got distributable net income. So you have, for one simple little trust with one 1099, you could have different amounts for each one of those. So I'm going to delve into that. I think the grantors might be interested in this. I know the attorneys are and practitioners are. I speak before the Central Florida Bar, and this one always is coming up. What do we distribute, right? Code section and reg section 643B or 1.643A pretty much govern what DNI is. What DNI is not, and I see this on the tax return all the time, DNI does not include capital gains unless the trust document specifically allows for it, or, and this is a little weird one, if the trustee has all along had a reasonable idea and is impartial why they're doing this, and they're doing it consistently, that has been allowed, but it has to be done consistently, and it cannot be done, well, this year I want to pass out capital gains because the person has the beneficiary has capital losses, so this year we're going to pass out capital gains. Next year we're not. It can't be done like that. And when you do consider capital gains into DNI, once it becomes DNI, the distributions are done pro rata. So you can't decide, I'm going to give them $10,000 and I want 8,000 to be capital gains and only 2,000 of the ordinary income to go out to them. I'm going to have the remaining, say 5,000 of ordinary income be taxed at the trust level. It doesn't work like that. It's done pro rata. So once it's DNI, everything is pro rata. Tax exempt income is pro rata, dividend income is pro rata, interest income is pro rata, tax exempt interest is all done pro rata based on total income to what gets distributed. And this is one that is consistently coming up. What I've done here for you, and when I'm going to look at two things. I'm going to look at both simple trust and complex trust. Simple trust, again, being a trust that is required to pass out all income. Okay. For purposes of interest income, that is income for both the tax return, for the accounting income, and for DNI. And I thought we had, did we get this slide put in here with my spreadsheet first? I don't see it. I'll send that back out to you too, because I've got a template that I use for what is and what isn't. That would be helpful. So I share that with a lot of people. I actually share it with my staff too, so they know. Tax exempt income. It's not deemed ordinary income for purposes of DNI, and it's never in the income of the tax return, but it is included for what is required to get distributed out to the beneficiary. So when you consider what's DNI, what is required to be distributed, it is the lesser of accounting income or DNI. Okay, so keep that in mind, because a lot of times on the tax return, you'll see a worksheet, which I'll show you in a bit. And they say, well, but this is DNI. I said, yes, that is DNI. And you would think that's what you're supposed to distribute, but it's actually the lesser of accounting income and DNI. And we didn't used to have a problem so much with this until the IRS 10 or so years ago decide that investment fees are no longer tax deductible, which has thrown a real curve in how all of this stuff is calculated. So capital gains is income on the trust tax return, but it is not part of accounting income or DNI, unless, again, there's always an exception, unless the trust document specifically says it is. I've got a couple of them that say we want, and they're quirky. They'll say, okay, we want 50% of the ordinary income to come out, and we want 10% of the capital gains to come out. That trust document will override statutory definition of what DNI is or what's required to be distributed. Trustee fees. And you'll see in this case, I have trustee fees over on the left of $2,500. However, because we had tax exempt interest, they make me allocate those trustee fees and tax prep fees, and not investment fees for purposes of tax return, but for purposes of accounting income. They make me allocate those expenses across the board. Okay, so you will see in this case, I kind of show you at the bottom what my ordinary income was. It was the 50, the 10, and the 40. 10 of which was tax exempt interest. So 10% of those items, the trustee fees and tax prep fees, attorney fees as well, I didn't put them in there, but it's in the same category. 10% of those expenses are not deductible. So you will see I've subtracted 10% of those fees to come up with a tax return. Okay. Step over to the accounting income. For purposes of accounting income, trustee fees, tax prep fees, and attorney fees, and investment fees, 50% get allocated to the ordinary income, and 50% get allocated to corpus. Okay, so they're not going to, what brought that on is, and I'll use the case of second marriage, second spouse, the husband dies, he has a kid from a previous marriage, and the kid from the previous marriage is managing the trust. That never ends well in most cases, but the second spouse gets income for her lifetime. Well, he doesn't like his stepmom. So he's going to manage that portfolio to have what? All capital gains, because she gets none of it. And so what the IRS says, you know what, you're not going to charge that income beneficiary with all these fees and not give her any of the income out. So we're going to make you at a minimum divide it 50-50. And that was their way of trying to ante up something. There is a provision, and if you can see that a particular fee is associated to one type of transaction, say you have a attorney fee that's related specifically to a real estate deal, you are permitted to allocate it to just that real estate deal. But for most cases, it's a 50-50 split on it. So already we're seeing, you know, a difference now between tax return, accounting income, and DNI, right? Investment fees, not deductible any longer on a tax return, which is now causing taxable income in a lot of the simple trust returns that we didn't have before. But they are deductible 50% for accounting income, okay? DNI, they're not, because I've done it in this spreadsheet, but typically DNI starts with taxable income. If you're looking how you're doing that, you're going to start with taxable income, work your way down, and then you add back the tax exempt income that needs to be distributed. Although I had $10,000 in tax exempt interest up above, my add back is the income less the expenses that got allocated to the taxable income. So, and that's what I have a statement there. It's adjusted for the reduction in expenses. So now we see our income for the tax return is $111,400. Our accounting income is $95,500, and our DNI is $96,000. Okay. For purposes of required distribution, it's the lesser of accounting income or DNI. So you'll see your required distribution is $95,500. But you don't get a deduction for the whole $95,500, because part of that is related to tax-exempt income that's not being taxed. So when you work through the formula, it's the number prior to that add back. So I'm only getting a deduction prior to the add back of tax exempt of $85,950. So now I have taxable income at the trust level. Remember, this is a trust that's required to distribute out all income of the $25,150. And how I have my staff prove it, it's it's the capital gain income that you get to pass out, plus it's the reduction for the exemption. Simple trusts get a $300 exemption, minus the expenses allocated for the tax exempt. So I have taxable income here at that trust. So now we're running into issues, because now I'm going to have to liquidate corpus to pay the tax on this, right? So it's kind of that ever revolving circle. What came first, the chicken or the egg? Especially as I'm paying items that are not deductible, such as investment fees. I'm reducing my corpus, but I'm not getting a deduction for it. So that corpus already is by nature going to be reducing as you go along. Okay. So this is a big thing that a lot of people are, especially with the advent of investment fees not being deductible, is caught some people in some precarious situations, especially if they say a lot of the old school, they were only having CDs, or they were only having treasury bills. They weren't going to get into equities. Well, then they were having to liquidate CDs, or we were having to liquidate treasury bills or something in advance to try and fund all of this. Same thing goes, I'm going to go back now to a complex trust. Well, let me look at first. This is how that tax return will look like when you see it. You'll see the income coming down. You can see on page 2 of the trust return. Well, this is actually the worksheet that comes out. This is the worksheet that it's in our software program, it's optional. I have them review it and make sure they're in agreement with what it calculates, because sometimes it doesn't always do that, especially when you come to certain things. Like if I have a stock dividend is income for taxable purposes, but it is not income for accounting income purposes, because they didn't get cash. They only got a piece of paper. So there are some things that have to be adjusted for it. And most softwares, I haven't found one software yet that accommodates that. So there are some special items that you need to trigger out there, especially if you have some quirky language in a trust. So you will see in this case, my accounting income was less than my distributable net income. So that is what I get as a deduction. And this is the amount that is required to be distributed out to the beneficiary. The simple trust, again, has a reasonable period of time to make that distribution. If they haven't done it within the year, I have a wording on my transmittal letter for the trustees that I tell them it has to be done before 4/15. Doesn't really have to be done before 4/15, but if they forget to do it after the tax return is done, chances are they're not going to remember, and it's not going to get done. And I don't want to have to go back and look, well, did you make that distribution that you needed to make? So it kind of gives the trustee, it's easier for them because they have a checkoff. Instead of saying at some point in time you need to make this distribution, well, that some point in time may never occur. So I tell them 4/15, and then they have their marching orders. And the trustees are pretty good about, if I give them stepping things, action items to do, they want that checkoff box. They want to know what to do. So let's look at a complex trust. Pretty much the same coming down, if you will, as what determines tax return, taxable income, accounting income, and distributable net income. But the difference here is the trustee gets to decide whether they distribute out $95,000. Typically in these cases, you will see that trust document, especially if it's for a B-type trust, that they require the income beneficiary to use their other sources of income first before we distribute the income out of this one. So that's why they may or may not be distributing all the income out of the trust. If possible, I try to distribute the income, but I'm not always allowed to do that. So in this case, I decided we're going to make a $50,000 distribution. But remember, part of that, when we talked about before, part of that 10% is related to tax exempt income. So I only get a distribution deduction for the $45,000, not the full $50,000. And so in this case, we have taxable income of $66,300. I have the amount distributed is 50,000. And then when we go to look at what happens, you will see I've gotten the distribution here. There's my distribution to the beneficiary. Although they have gotten $50,000, only 45,000 of that is taxable to them, and that will be, they'll get that on a K1, and it will be pro rata to the income sources up above. Again, the capital gains stays at the trust level unless the trust document provides otherwise. Same type of thing, the spreadsheet I force my people to use, because even at this point in time, I've been doing it for 20 years, I always look at this to make sure it's done correctly, because I don't have confidence that for some reason that it's been picked up quite right. Common mistakes. I don't know, Carl, you want to step in here? I mean, you've got some battle scars on you.
Well, yeah, I think probably the most common mistake is not reading through the trust document, maybe not getting a copy of the trust document. And reading through the trust document, I think you really have to read through multiple times, especially if you're just coming into this for the first time, you've never been a trustee before. There's going to be a lot of probably legal terms you're not familiar with. So I think it really helps you to read it multiple times, try to gain an understanding. If you can get access to the lawyer who drafted the documents, that would be very helpful, as Carol mentioned in the very beginning of some of the steps to take. If not, maybe reach out to the firm if that lawyer is no longer in practice, because some of these documents are 20, 30 years old. That's what you're working with. So understanding that document, and things change over 20, 30 years. So it may not be as clear and as simple as it was. So that's the first thing that I think you need to know. As Carol explained here, knowing the type of trust, simple, complex, revocable, irrevocable, those all make a determination. So it does make a difference, and you do have to have a working knowledge of that. Not providing the accounting to beneficiaries can be very key. Everybody's friendly in the beginning. Everybody's hopeful they're going to get income passed out to them. But when things go awry and money is involved, I think people's temperament changes very quickly. And even though you're family, potentially, most times, but not always, money can divide families, unfortunately. And we've seen it happen many times, and it's quite unfortunate. So I think making sure that you're following your duties as trustee, and one of those is getting the accounting to the beneficiaries, is quite key. You do need to keep records for your distributions, especially if you're doing something in the complex area where you're not always getting out D&I, passing that out to the income beneficiaries. What's your justification? Are you doing it? What's your reasoning behind it? Are you doing it on a yearly basis, or are you just changing it? Hey, they invited you to Christmas this year, so you're going to pass out more income. Whatever rationale, you probably want to have something more than that. You got a card or something. So I think you want to use the rationale, be justified, and making sure that you're responsible when you're passing out distributions.
And on this one, real quick, I want to add, when we do distributions out of a trust, now a lot of times we set it up where they get monthly distributions, but at the end of the year, I send out the accounting to the trustee, and I make them sign what I call a receipt and release of any distribution. I make them agree to the accounting first, and in my accounting is I give them the 6-month statute, which is provided for. I make them sign that they have received it. Now, they don't have to agree to it. They have to sign that they have received it, because that only gives them then 6 months to bring up any action against you, okay? So if you're giving out accounting, make sure you give them the language with that accounting, and you're a CPA or your attorney can give you language that they like to use that establishes that 6-month liability period. And then when you give a distribution, Make sure that they're signing what I call a receipt and release. Attorneys call it maybe something a little bit differently, but that's pretty much the common term, that they acknowledge that they are receiving this as a distribution. Because a lot of times they'll come back, well, I thought it was a gift. Well, who told you it was a gift? It was a distribution. Or if we decide that, and I've had to do this on rare occasion, but if something happens and I have to pull money back into the trust for whatever reason, they acknowledge that if that is a requirement, they have to cough up the money and bring it back. So I rarely ever do any distributions without that. I typically make them sign it at the end of the year. Carl, because Carl has his investment licenses and all, which is why he's really helpful to me when we're dealing with some of these trusts. But Carl, I'll let you talk about the prudent investor rule, because the trustee is liable for the investments as well.
Right. So the prudent investor rule really is looking at you're not supposed to be maybe as risky maybe as you would be if this were your own money. You're investing prudently for the beneficiaries. You're supposed to be looking after them, shepherding them in a way. That's what the grantor is set forth in the trust document. So we have seen people hire firms that have been day trading, maybe put something into cryptocurrencies. Those probably would not pass the prudent investor rule. So there again, everything's fine and going along well when whatever investment you're in, if it's on the upswing and you're making money. But as soon as something turns and you've lost 20, 30, 40% of your principal, they're going to come crying wolf if they do not feel that you've been prudent. So I think that's why you want to start out in the very beginning and make sure that you're following the guidelines sort of set forth there.
And you're hiring an investment professional that knows to deal with trust. It looks like we're at the end of this seminar here. I don't want to run anybody over because no any questions, Julie, Kate, that we need to answer for the group?
Not that I'm seeing yet, but guys, if you have questions, we still have a couple more minutes. It's 11:53. We run the webinar till noon. So if you have any questions, now is the time. And it sounds like you guys are probably done with your presentation. So if you want to come off mute and ask a question, please feel free. But thank you for all this good information. I think everybody would find this is very, very helpful. You went very in depth with stuff. It's interesting. This is
hopefully I know some of the
here at Aged. We do have a question. Are beneficiaries post-death entitled to a copy of the trust?
Beneficiaries
post-death.
Well, it wouldn't be the beneficiary. It would be the executor of that account. And the distributions would stop at point of death, and then the remainder beneficiaries would step in. Typically, the trust document will say any amounts that were not distributed go back into the trust, and then the remainder beneficiaries step in, is typically the wording you see.
Are those remainder beneficiaries entitled to a copy of all that stuff? So the trust?
Yes, they are.
Yes, they are.
The remainder beneficiaries are entitled to anything they want once it becomes irrevocable. They can ask for a copy of the tax return, they can ask for accountings, and they're actually required to get accountings, which is, I can tell you, cause for a lot of, especially in the guardianship cases. You see mom and dad are a guardian, right? And mom and dad are incompetent, and they don't want to mess with dealing with mom and dad stuff. They want someone else to, but they can point a finger, well, you're not doing this right, you're not doing this right. Well, it's like, it's really easy to say what you shouldn't be or shouldn't be doing, but step into the shoes of the guardian. The guardian can't go out there and invest the money in, these things that might be paying a higher dividend. They got to make sure that principal is conserved and there's no risk of loss. So how they're investing for that person is different than if they were alive and 40 years old, right? So it's very easy to play, couch quarterback to someone. So that's why, there's where your liability is with these remainder beneficiaries, or with the children of the person that needs a guardianship.
That's a really good point. And then it looks like mostly we don't have any other questions, but everybody's saying thank you. They thought your presentation was very informative. You gave them very thorough advice. They're very appreciative of everything you shared today. And guys, I'm sure if you have questions, you can reach out to Carol and Carl and pick their brains, because they are a wealth of information and knowledge about all these other types of trusts that AGA doesn't even deal with. This is all sorts of stuff. There's all these other kinds of trusts out in the world that you need to be aware of. So.
But especially for the guardians, surround yourself. I mean, the world you operate in is so litigious. It's just so litigious, and no one really wins in that environment. Surround yourself with good professionals that know what they're doing, and that's my bet. Surround yourself with a banker that knows what they're doing. Surround yourself with attorneys that know what they're doing. Surround yourself with CPAs and investment people that are familiar with these guardian accounts, that are familiar with trust accounts, because it's not the norm. It's just not the norm. Okay. Well, thank you, everyone. You've got my phone number. She's going to share the slides. Feel free to reach out to me or Carl if you have any questions afterwards.
Yes,
Thanks,
you
everyone.
very much.
Thank you.
And real quick, while I still have you guys, we are going to be taking a break for the summer for our webinars, and we will return, it looks like, in September with Brandon Arkin to talk about maximizing home care. But we get a little busy here at AGA with conference season, so we tend to take a little bit of break during summer. So this was the last big hurrah, and then we'll see you guys all again for webinars in September. But thank you, Carol. Thank you, Carl. We appreciate all your knowledge and sharing with our audience.
Bye-bye.